Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who've been watching the channel for a while, you know back several months ago we did a video about suppressors and are they legal in Washington State. Now that in turn led to a follow-up video about can we use solvent traps and convert them into suppressors in Washington State. And at that time, we made it very clear that we did not think that was a good idea. Well, recently we had to do a video now about is the ATF really coming after those that purchase solvent traps? And that, of course, is based upon a nasty little letter that a lot of folks got who had purchased solvent traps from a company called Diversified Machine. Now, after I did that video, I got a lot of feedback from people privately, and everyone kind of fell into one of three categories. And they wanted further clarification. I actually took it upon myself to reach out to the ATF to see if we could really get some further clarification. And lo and behold, the ATF did in fact respond. So today, this is an important update. Let's spend a few minutes talking about the ATF response on solvent traps. Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click the like button down below. If you want to stay up to date on issues related to your Second Amendment rights, go ahead and click the subscribe button down below. Click the little bell logo if you want to be notified when we post new videos. Most importantly, let's keep the comments and discussions coming. That's how we're going to make sure we get our videos out to more lawful and responsible gun owners like yourself. Okay, so for those of you who have been following this issue, the issue is one of solvent traps, which can be quite easily milled out and converted into suppressors. Now, on a previous video, we talked about a recent raid by the ATF of a company called Diversified Machine. Now, Diversified Machine is a company who produced a lot of these. And of course, when the ATF raids a facility, they're not just going to take the machinery and all of the inventory and things like that. No, they're going to take all the sales records. They're going to take all the shipping records. And so what happened is a bunch of folks ended up getting a nasty little letter from the ATF. They got a nasty little letter from Keith Kralchek with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, basically saying that, hey, we know you bought one of these, you need to turn it in. Now, the issue when you read this letter, of course, is the ATF was basically made it seem like, listen, just purchasing these solvent traps as is was unlawful. It constituted a suppressor or a silencer, and therefore the mere purchase and possession of it was unlawful. Whether you'd milled them out, whether you'd done your ATF Form 1 or anything like that, appeared to be irrelevant. So I got a contact from quite a few of you privately about this because you had received letters because you'd purchased some of these from Diversified Machine, which at the time when you purchased them, there appeared to be nothing unlawful about it. Now, I had three categories of people who contacted me, okay? The first category is people who purchased these solvent traps, but really never did anything with them. They're either still in the box or maybe they used them as a solvent trap, but they didn't use them for any other purpose. Are they actually required to turn these in? The second category of people were those who purchased them, did alter them and mill them out, convert them into suppressors, but didn't do anything else. And I knew the answer to that question, but I wanted to see just how bad that may be. Now, the third category, and I had some people who fell into this category, were individuals who purchased them as solvent traps, did mill them out, but in at least two instances, went through the appropriate ATF paperwork, paid the tax stamp, and actually were approved by the ATF to possess them. And yet they were still receiving these letters. So did they have to turn them in also? So those are the three categories of people we need to give you very important updates. Okay, so with all of these points of clarification, I actually attempted to contact the ATF and speak to legal counsel over there to figure out some clarification on this. So what I ended up doing was calling the ATF local office here in Seattle. Of course, I was routed to the Detroit, Michigan office because Keith Kralchek, the special agent in charge of this project, was the one that signed the letter. So I had to then talk to the Detroit, Michigan office. The Detroit, Michigan office forwarded me to the Flint, Michigan office, who then forwarded me to ATF counsel, who happens to be here in Seattle. And his name is John Tibbetts, and so Mr. Tibbetts and I did have a conversation. It took me about 2 days to actually connect with him, but candidly, the ATF was mildly responsive to my requests. And so Mr. Tibbetts and I were able to have a phone conversation. Then he asked that I write my questions down in writing, email them to him, and I did so, and he got some answers back. What I need to do, and this is important for all of you, is I need to give you this updates, because some of you are wondering, what do I do now that I got this letter, in whatever category you may fall into. So I'm going to be sharing you verbatim the questions and answers that I asked Mr. Tibbetts with the ATF, so you can understand what you're doing. Now, again, I'm not here to advocate or anything like that for the use of these or anything of these solvent traps or anything like that. What I'm here to do is to tell you what the law currently states, what law enforcement currently states, so that you can make informed and educated decisions on how to operate within the confines of the law. Okay, the first category of individuals are actually the most common, and these are people who bought them as solvent traps and really never did anything else with them. Maybe used them as a solvent trap, but was never converted, never used for any sort of unlawful purpose. And the question read, those that purchase solvent traps and have done nothing to them, leaving them in the original condition and configuration. Based on the language of the attached letter, it appears that the ATF views these devices standing alone to constitute a silencer. I would ask for clarification as to the ATF's position on those that have made no alterations to these devices, nor have they used them for any purpose other than its stated purpose. Okay? And the answer that I received for these individuals, according to ATF counsel, was as follows. Even though the customer may not have made any changes to the purchased solvent traps, parts that are intended only for the use in such assembly or fabrication constitute a silencer in and of themselves. A silencer is defined under the Gun Control Act of 1968 and the National Firearms Act to mean any device for silencing, muffling, or diminishing the report of a portable firearm, including any combination of parts designed or redesigned and intended for use in assembling or fabricating a firearm silencer or firearm muffler, and any part intended only for use in such assembly or fabrication. And they cite to United States Code section 921A24. The answer further goes on to state that as an NFA firearm, silencers, including silencer parts, must be registered by the manufacturer or maker of the firearm in the National Firearms Registration and Transfer Records, NFTR. A limited exception exists for special occupational taxpayers engaged in the business of manufacturing silencers who possess unregistered silencer parts. And so what the problem here is they're saying that the problem is not that you bought it. It's the problem is that Diversified Machine, who was clearly making silencer parts, had not gotten ATF's blessings to do so, had not gone through all the appropriate paperwork and taxation and all of that. And so therefore they were selling you contraband. And because you purchased contraband, you must now turn those in. Now, of course, the next category of individuals are the ones that I'm most concerned about. Those are individuals who did purchase these solvent traps, did make alterations to them that would convert them into a suppressor, and have not registered them with the ATF. The category of individual, as I described to Mr. Tibbetts, was as follows. There have been a few who have admitted that these have since been milled out and used. While I know the answer to how the ATF will view, and for obvious reasons, my concern is that while all of these folks will gladly relinquish them immediately, they are concerned about criminal liability should they disclose their identity. The letter states that an ATF office should be contacted within 30 days of receiving this letter to coordinate the abandonment of any silencers. Is the ATF asking for all solvent traps, in this case manufactured by Diversified Machine, to be surrendered, or only those which have been altered and are in clear violation of the applicable U.S. codes? So again, I was asking for clarification, like, are you talking about all of them or just those that are milled out? And if they're the ones that are milled out, what sort of criminal liability are these people subjecting themselves to potentially? The answer I received was as follows. ATF is asking for all solvent traps manufactured by Diversified Machine to be surrendered, as the federal definition for a silencer includes, quote, any part intended only for use in such assembly or fabrication. See United States Code section 92A24. The NFA makes it unlawful to possess a silencer that has been made or transferred in violation of the protections of the Act. See 26 U.S.C. Section 586. Since these silencers had not been registered and transferred by Diversified Machine to the current possessor, current possession is in violation of the NFA. Any decisions regarding criminal liability will be made by the respective United States Attorney offices. So, yeah, I think it's pretty clear you need to surrender these. The problem here is they're not going to give us a clear answer on what sort of criminal liability. Now, I have sent follow-up questions to Mr. Tibbetts based upon these responses, and we'll be doing another video as soon as we get those responses back. But the problem here, as they're saying again, is listen, even if it didn't matter what you did with it, because when Diversified Machine failed to go through all the appropriate ATF channels in manufacturing these parts, that in and of itself made the solvent traps in and of themselves unlawful. Okay, and then the third and final category of people, and yes, I have talked to 2 people who did this, is those who did purchase them as solvent traps, did alter them and mill them out, but went through all the appropriate ATF paperwork, including filling out the Form 1, including paying their tax stamp, and including receiving the approval letter from the ATF. Now, certainly the ATF is not asking you to surrender a suppressor that they have since already anointed or blessed you with and allowed you to lawfully possess, right? I mean, they wouldn't do that because the ATF never moves the goalposts, right? Well, unfortunately, the answer is no. You are also being asked to surrender. Now, I want you to pay careful attention to the end of this answer because this is something we're going to need to talk about also. But the answer I received from Mr. Tibbetts was as follows. Yes, individuals who have completed Form 1 and received approval from ATF are being asked to surrender their silencers on the basis that any silencer or silencer part made by Diversified Machine required Diversified Machine to submit an ATF Form 1 to the NFA division for approval and payment of a $200 making tax. The ATF Form 1 effectuates registration of the item in the National Firearms Registration and Transfer Record. The subsequent transfer of a silencer or silencer part to you as the customer required the submission of an ATF Form 4 to the NFA division for approval and payment of the $200 transfer tax. ATF has information that this procedure was not followed. An ATF form submitted by you, the customer, does not alleviate the previous unlawful transfer or registration of the silencer or silencer parts. Therefore, you must surrender any silencer or silencer part to your local ATF field office or provide proof of destruction of the silencer or silencer part to your local ATF field office. You should be aware that the silencer or silencer part that you possess was unlawfully registered and will be removed from the NFRTR. Under the NFA, 26 U.S.C. Section 586, it is unlawful for any person to receive or possess a firearm transferred to him in violation of the NFA or made in violation of the NFA. So what are they saying here? In a nutshell, listen, Diversified Machine should have gotten ATF approval that they were making suppressors. They didn't do so. Therefore, when they sent you that solvent trap, you didn't need to do a Form 1 because you were making a suppressor. You actually needed to do a Form 4 because you'd already purchased the suppressor. And the problem lies with Diversified Machine. Now, here's the thing. I think that we can all agree that this last category of person is the one who is certainly within the most confines of the law for someone who perhaps used these solvent traps for some other purpose. And what they're saying here is that you must either arrange for surrender or you must show proof of destruction. Now, what I'm not seeing that is for the other 2 categories. If you just purchase this thing, you're being asked to surrender. If you purchased it and converted it and didn't do any paperwork, you're certainly being asked to surrender. And that's the category of individuals that I am most worried about. Now, I want you to remember that in addition to the problems that we have with the ATF if we purchase one of these, which of course is based upon federal law, what Diversified Machine has done here has also created a big problem for all of you who purchased it on the statewide level. Let's remember that RCW 9.41.250 subsection C specifically states, every person who, uses any contrivance or device for suppressing the noise of any firearm unless the suppressor is legally registered and possessed in accordance with federal law, is guilty of a gross misdemeanor punishable under 9A.20 of the RCW. So yes, and again, we got the link to the video right there. You can have suppressors in this state, but you have to go through all the appropriate federal channels. Now, the problem is what the ATF is saying here is that, listen, Diversified Machine screwed it all up, that it doesn't matter which category of person you're in, purchased it, converted it, purchased it, converted it, and did all the paperwork, they're still unlawful and you have to turn them in. Okay, so once again, everyone's kind of falling into three categories, and yet it doesn't really matter. The ATF is saying you need to surrender all of these with one exception. If you purchased the solvent trap, didn't do anything else to it, the ATF says you need to surrender. If you purchased the solvent trap and converted it and didn't fill out any paperwork, the ATF wants you to surrender. And by the way, you're the category of individual I am most concerned about. The third category, the anomaly here, is if you purchased it, converted it, and did all your ATF paperwork, which would have been a Form 1, the ATF says, it's no good anyways because Diversified Machine screwed it all up. You would have had to do a Form 4, therefore your paperwork's no good. We're going to strike it from the NFA, and you need to surrender or provide evidence that you destroyed it. Now, why are only they being given that option? That's one of the questions of inquiry we have with their counsel, Mr. Tibbetts, and as soon as we have the answers, we will let you know. I think there's going to be some more developments, so stay tuned here. As we learn more, we will make sure to get information out to you so we can always operate within the confines of the law. Listen, I know you're going to have some more questions about this or anything related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at Washington Gun Law, or of course you can call us directly at 425-765-0487. Now remember, part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every single situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.